Hello, I'm Jessica Ryan Keeney. I am licensed to practice law in the state of California. I'm the Department of Child Support Services attorney for two small Northern California counties. I've been practicing family law since I was sworn into the bar in December of 2009. What I'm going to tell you today is not legal advice. It is for educational purposes only. Go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload future content. And what are we going to discuss today? Well, today we are going to discuss the court's ability to impute income to the custodial parent or the parent receiving support. Usually the custodial parent and the parent receiving support are the same, but sometimes they're not. And we're going to discuss both. So, as always, we're going to look at what the statute has to say about this. In relevant part, Family Code section 4058B reads, 1. The court may, in its discretion, consider the earning capacity of a parent in lieu of the parent's income, consistent with the best interests of the children, taking into consideration the overall welfare and developmental needs of the children, and the time that the parent spends with the children. And then subsection 2, actually I think that's subdivision 2, anyway, B2, when determining the earning capacity of the parent pursuant to this subdivision, the court shall consider the specific circumstances of the parent to the extent known. Those circumstances include, but are not limited to, the parent's assets, residence, employment, and earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the parent, prevailing earnings levels in the local community, and other relevant background factors affecting the parent's ability to earn. So I've chosen a number of cases to discuss because they illustrate what we need to know about the court's ability to impute income to the custodial parent or to the parent receiving support. And I'm not going to give case citations as I'm going through all of this. All of the case citations can be found in the description down below, and link to the Family Code section that I just read can be found in the description down below, and a link to my website where a write-up, which is pretty much what I'm reading now, can be found in the description down below. Go check out the description down below. It has good information. Check out the description in all of our videos. It has good information. Okay, without further ado, in remarriage of Paulin is a case in which the following relevant facts exist. Mother and father were married, they had 2 children, they divorced. By stipulation and order, they agreed that father would pay $1,511 per month in child support based on father's income as a police sergeant and mother's part-time income as a registered nurse. Mother was the custodial parent and the parent receiving support. Father remarried and had 2 children with his new wife. Mother remarried and voluntarily quit working. The trial court granted father's request to decrease child support by giving him a hardship deduction for his new children and imputing mother part-time registered nurse income, even though she was unemployed. So mother did not appear at the hearing on father's motion to decrease child support. However, she provided a declaration that explained that she quit her job as a nurse because it was very stressful and because of questionable record keeping by her employer. And she periodically reviewed help wanted ads in similar sources looking for a job, and she hadn't found a job appropriate for her level of training and experience. The trial court set child support based on mother's ability to earn as a part-time registered nurse, used mother's actual income as a part-time registered nurse, gave father a hardship deduction, and made the order without prejudice so that mother could later prove that her loss of income was justified. Basically, that income should not be imputed to her. They left her the ability to later prove that income shouldn't be imputed to her. So the hardship deduction is an issue for another discussion. We're not going to discuss that here. That's a different topic. The Court of Appeals answered the question, did the trial court err in attributing or imputing income to mother based on her earnings capacity when she was voluntarily unemployed? And I'll tell you that this is a 1996 case, and these cases are in order in which they were decided. And that's going to be important because we're going to see a little bit of a progression as the cases go on. So the Court of Appeals held where the former wife had remarried and had voluntarily ceased her employment, the trial court did not abuse its discretion in fixing her income for purposes of the statutory child support formula based on her earning capacity. The court further held when child support is ordered at a time when both parents are employed and thereafter one arbitrarily decides to stop working, perhaps because of remarriage or to someone with significant income, the court must possess the discretion to consider that parent's earning capacity in ordering child support. Otherwise, one parent, by a unilateral decision, could eliminate his or her own responsibility to contribute to the support of the child, causing the entire burden of supporting the child to fall upon the employed parent. The court recognized that the courts must be able or must have the discretion to consider the earning capacity of a parent in setting child support. Otherwise, one parent could shift the burden of supporting the children to the other parent without the input of that other parent. Next, we have in remarriage of Hinman, and this is a 1997 case. This is also known as Hinman 8. Mr. and Mrs. Hinman were very litigious and had a whole bunch of appeals, and this was the 8th appeal. So this is a case that does not deal with the court imputing income to the custodial parent. However, it's part of the discussion because it marks a change in the way the court deals with imputing income to a parent, and it's cited by cases that deal with imputing income to the custodial parent. So here we go. We're going to discuss it because it creeps into the discussion in later cases. In this case, mother was the parent paying support, or the non-custodial parent, and she had supervised visits with the children. Father claimed that mother accepted a lower paying job because of the child and spousal support case. Mother later became unemployed and had 3 children under the age of 3 that she was solely responsible for caring for. And these were children from another relationship. Mother claimed that she could not work because of this. Father wanted income imputed to mother and met his burden of proving that mother had the ability and opportunity to earn an income. The court imputed income of $3,200 per month to mother and ordered mother to pay father child support of $1,248 per month. Mother argued that the trial court improperly imputed income to her based on her earning capacity and argued that the court may not impute income to a parent unless the parent is intentionally avoiding her financial family responsibilities. The Court of Appeal held that the trial court did not abuse its discretion in imputing income to mother based on her earning capacity. The court held we declined to adopt a per se rule, and this is the Court of Appeal that held this. We declined to adopt a per se rule that the trial court must only consider parental earning capacity upon a showing of bad faith. Instead, we adhere to the plain language of the Family Code, which grants the trial court broad discretion to consider parental earning capacity consistent with the best interests of the supported children. And this is Family Code section 4058, subsection B. The courts also declined to adopt a per se rule prohibiting the imputation of income to parents who refrain from employment in order to care for preschool-aged children in all cases. Instead, that's the court, hold that the question whether earnings should be imputed to an underemployed or unemployed parent is addressed to the sound discretion of the trial court. All circumstances relevant to the determination may be considered by the trial court upon representation by the parties, or upon presentation by the parties. This is of particular interest because often parents with preschool-aged children argue that child support should not be imputed to them because of the age of their preschool-aged children. Here, the court declines to find that income should not be imputed to parents in mom's situation. Instead, the court holds that the trial court has discretion to impute income to a parent with a preschool-age child. And that's the situation mom was in. She had a preschool-age child or preschool-age children, and the court still imputed income to her. Though this case does not deal with imputing income to a custodial parent, it's discussed here because the court held that they are not adopting a rule that courts may only consider earning capacity when the court finds that the parent to whom income is being imputed is acting in bad faith. And this is important because before this case, there were cases that had a 3-prong test for imputing income. And one of those prongs was that the parent was acting in bad faith, basically. Trying to shirk their duties, not looking for work. They weren't willing to work. Anyway, so the court doesn't have to find that a parent acted in bad faith in order to impute income. Additionally, this case is cited by other cases in which income is imputed to the custodial parent. Additionally, the court recognized that imputing income must be in the best interest of the children that support is being paid for. And that's important as well. That's cited in the upcoming cases, and that seemed to be a change in the way that the court was ruling on things, requiring that there be a finding that imputing income is in the best interest of the children. And I realize that the law says that imputing income has to be in the best interest of the children. I don't know what the law actually said at the time that these cases were decided, because I wasn't practicing law then. Okay, next one is in remarriage of LaBass and Munsee. I hope I pronounced those right. And this is a 1997 case. In remarriage of LaBass and Munsee is a case with the following relevant facts. Mother and father were married and had 2 children. While married, father worked full-time as a high school teacher, and mother worked part-time and completed her master's degree in English literature. After mother got her degree, she started working full-time at Home Depot. Mother and father divorced in Sacramento County. Father agreed that mother and the children could move to Southern California so mother could either pursue her PhD studies or for further employment. Mother didn't try getting her PhD. Instead, she got a second master's degree, this one in fine arts. She lived rent-free in her parents' studio apartment, and she sometimes took substitute teaching jobs and eventually took a part-time instructor job at a community college. Mother got paid $824 per month for this. When the children were with father during the summer, mother still refused to work anymore. Father, on the other hand, took a summer job with Sacramento Community College and earned an extra $3,500. Mother had an emergency teacher credential that allowed her to substitute teach at any subject anywhere in the Los Angeles school district. Father filed a motion asking to modify child support and to impute income to mother. Father met his burden of proof, showing the level of income the court should impute to mother. Among other things, father presented ads showing the jobs available to mother in the Los Angeles area. In her testimony, mother made it very clear that she didn't intend to work full-time. The court imputed income to mother based on full-time employment and based on the evidence that father presented at trial. There were a number of nuggets in this case, and some of them aren't exactly relevant to this discussion, but I'm going to mention them because I really like them. Okay, so mother argued that imputing income to her Mother argued that in imputing income to her, the court, this is the trial court, departed from the mandatory guideline child support calculation and therefore had to state in writing or on the record why they departed from the guideline. The Court of Appeal held that imputing income was not a departure from the guideline child support and that the court merely exercised the discretion expressly vested in it by Section 4058 Subdivision B to substitute earning capacity for actual income in applying the guideline formula. The court recognized that some early cases held that imputation of income may only occur where the court finds the parent in question was deliberately trying to avoid his or her child support obligation. And that's what I was discussing earlier, acting in bad faith. And this is Philbin v. Philbin, in remarriage of Catalano. Yeah. Those are the two cases that the court cited there. However, the court found this interpretation no longer prevails. So the court no longer needs to find that a parent is deliberately avoiding his or her child support obligation in order to impute income to them. The court held recent decisions of the Court of Appeal now recognize a finding of bad faith is no longer a prerequisite, as long as ability and opportunity to earn exist. The court has the discretion to consider earning capacity when consistent with the child or children's best interests. The court cites marriage of Hinman. This would be Hinman or Hinman 8, as well as Padilla or Padilla, and marriage of Everett. So the court cited Family Code Section 4058B, which states, the court may, in its discretion, consider the earning capacity of a parent in lieu of the parent's income, consistent with the best interests of the children. So here the court recognized that imputing income to a parent must be in the best interests of the children. I said earlier I don't know what the Family Code said at the time. Here we go. The cases tell us what the Family Code said at the time about imputing income being in the best interests of the children. The court found that father met his burden of proof in showing the income that should be imputed to mother. Among the evidence he presented were ads showing the jobs available to people with mother's qualifications in the Los Angeles area. The court cited Longergan v. I'm going to mess this up. Sholnick, in finding that ads were admissible for the non-hearsay purpose of showing that offers to bargain exist. That's one of my favorite findings. I love that one. I cite it. Okay, so the court held that father bore no burden to convince the court that mother would have secured a full-time job had she applied. Rather, it was incumbent upon mother to show that despite reasonable efforts, she could not secure employment despite her qualifications. And the court cited marriage of Stevenson when in that quote, and given mother's unwillingness to work full-time, it was proper to impute income to mother. Mother argues that for policy reasons, women who have primary custody of the children should never be subject to income imputation provisions of Family Code Section 4058B. She claims that the policy considerations behind the Regency line of cases imputing income to the supporting parent should not apply to a caretaker whose refusal to realize her earnings potential is motivated by her perception of the best interests of the children. And the court was unconvinced by this argument and held this sweeping claim finds no support in case law or the guideline language. Section 3900 and Section 4053, Subdivision B, state unequivocally that both parents are equally responsible for the support of their children. Accordingly, Section 4058B makes no distinction between the custodial and non-custodial parents. Court cited in remarriage of Paulin. The court makes it clear that both custodial and non-custodial parents are equally responsible for supporting their children. Therefore, so long as all the requirements are met, the court may impute income to a custodial parent. So relevant to this discussion, the court found the following in this case. It's not improper for the court to impute income to a custodial parent when the ability and opportunity to earn exist and it's in the children's best interest. The court does not need to find that a parent acted in bad faith in order to impute income to the parent. Both parents are equally responsible for supporting the children. The parent seeking to impute income has the burden of proving the income that should be imputed. The parent asking that income be imputed need not prove that the other parent would get full-time employment or whatever employment he's trying to convince the court that the other parent has the ability and opportunity to get. The parent income is being imputed to has the burden of proving that even if he or she made reasonable efforts, he or she would not get any work, and that the court can impute income to a custodial parent. My favorite finding is that ads may be presented for the non-hearsay purpose of showing that offers to bargain exist. Next one is in remarriage of Cheriton, I think. So this was superseded on the issue of attorney fees by the case in remarriage of Morton. However, it's still a good case for purposes of its ruling on imputing income to a custodial parent, and it's cited by other cases on this issue. So in relevant part, the facts of this case are as follows. Mother and father were married and had 4 children. Mother performed and taught music. Father was a professor of computer science at Stanford University. Father was also a researcher and inventor as well as a consultant to Cisco Systems. Father and a partner sold Cisco their business, Granite Systems, Inc., and got a lot of vested Cisco stock options as a result. Mother and father separated in 1986. In 1988, mother and father reconciled. They separated again in 1994, and father filed for divorce. Mother and father agreed that father would pay child support to mother of $2,171 per month and spousal support of $689 per month. Mother and the children moved out of the family home and into a small house. The children shared the bedrooms and mother slept in the living room. Father stayed in the family home. At the time of trial, father's stock holdings between Cisco and other companies were worth about $45 million. Mother's Cisco stock that she got as part of the property division in the divorce was only worth about $1 million. Father made a lot more money than mother did and held a lot more assets than mother did. So relevant to this discussion, after a trial, the court imputed income to mother based on her earning potential and ordered father to pay mother $2,292 per month in child support for the 4 children. The court made other orders that are not relevant here, so we're not going to discuss them. This case also had a bunch of nuggets that aren't relevant to this discussion, and we're not going to discuss them here, but the case is worth reading, so I suggest reading it. Relevant to this discussion, mother argued the trial court erred in imputing income to her as it was not in the best interest of the children. The Court of Appeal referenced Family Code Section 4058B and stated, by express statutory provision, trial courts have discretion to impute income to a parent based on earning capacity. The court held case law also recognizes that discretion, and they cited in remarriage of Simpson and in remarriage of Hinman. Also, Moss v. Superior Court. The court further held recent decisions have even allowed courts to impute income to a payee spouse based on earning capacity, meaning the party who's receiving support. And they cited in remarriage of Paulin and in remarriage of LaBass Munsee. The court recognized that there was substantial evidence of mother's earning capacity in the record. However, the trial court made no finding that imputing income to mother was in the best interest of the children. The court reversed and remanded the judgment to the trial court on numerous grounds, including imputing income to the custodial parent without making a finding that it was in the best interest of the children. In short, in this case, the court held that income may be imputed to a custodial parent receiving child support based on the earning capacity of the parent, but the court must make a finding that imputing income to the custodial parent is in the best interest of the children. Next, we have in remarriage of Ackerman, and this is a case with the following relevant facts. Mother and father were married and had 2 children. One of the children had special needs. Father was a licensed physician with a successful plastic surgery practice in Southern California. Before marrying, mother signed a prenuptial agreement showing that the medical practice was father's separate property and setting forth the value of the medical practice. Mother was a stay-at-home mom during the marriage. She graduated from law school in 1995 but didn't pass the California bar exam. program. Father was ordered to pay mother child support of $10,070 for 7.5 months starting January 15th, 2004, then $980 per month starting September 1st, 2004. The reduced child support was based on mother's earning capacity. On appeal, mother objected to the court's imputation of income to her from her share of the community property without considering outstanding debts and the purchase of a residence in Newport Beach. That's where the parties lived, was Newport Beach. The Court of Appeal held that the trial court did in fact consider those factors. Wife cited In re Marriage of Kennedy, which holds the court must look to the actual, not theoretical, return on the property she receives. The court held here, after considering wife's or mother's need to purchase a residence, the court imputed a 4.3 or a 4.5% interest return on her assets because that was the government bond rate at the time. It did not require to invest the assets or invade their principal. We find no abuse of discretion. Mother also challenged the court imputing income to her for purposes of setting spousal support. And this is tangentially related to the discussion in this article, so it's worth mentioning. The Court of Appeal held the law is established that a trial court may consider earning capacity in determining spousal support. Again, cited Cheriton. A spousal support order requires the trial court to balance a number of different factors. Family Code Section 4320. One of these is the goal that the supported party shall become self-supporting within a reasonable period of time. This is Family Code Section 4320. The weight to be given this factor lies within the trial court's broad discretion. Again, Cheriton. Another factor within the court's broad discretion is the ability of the supported party to engage in gainful employment without unduly interfering with the interests of dependent children in the custody of the party. This is Family Code Section 4320G. The court considered these factors and found wife or mother's earning capacity was not impaired by her domestic duties. The Court of Appeal further held with respect to spousal support, unlike a child support order, a spousal support award does not require the court to consider the children's best interests. Moreover, unlike in Cheriton, the court here made express findings that the imputation of income was in the children's best interest. The court also found that there was enough evidence in the record, including mother's testimony and evidence from a vocational evaluation report, showing what mother's earnings capacity was, such that the court was able to impute income to her. The judgment of the trial court was affirmed. In short, the Court of Appeal held that a reasonable rate of return may be imputed to the investments of a custodial parent for purposes of setting child support. Spousal support may be based on earning capacity. Goals of child support and spousal support are different. One of the goals of spousal support is for the supported party to become self-supporting within a reasonable time, and that's not one of the goals of child support. The trial court found that imputing income to mother was in the best interest of the children. There was enough evidence to support imputing income to mother, and setting support based on her earning capacity was not in error. Next we have In re Marriage of Bardzik. I think that's how you pronounce it. So this one's a bit unusual because the custodial parent ended up paying child support to the non-custodial parent. And this does happen, but it's not the norm. In this case, mother and father were married and had 2 children. One of the children had special needs. The child with special needs was adopted, and the parents received adoption assistance for him. When they divorced, mother and father were both deputy sheriffs for the same agency, and they made about the same amount of money. They agreed to 50-50 custody of both children. They agreed neither party would pay the other any child support. They agreed mother would keep the adoption assistance each month. And after 20 years with the sheriff's department, mother retired at age 42, while she was still young enough and healthy enough to keep working. Father, on the other hand, kept working. At some point after the divorce and after this custody and child support plan was in effect for a while, the child with special needs went to live with father and the other child continued sharing 50-50 custody with mother and father. Father filed a motion to modify child support and get the adoption assistance sent to him. At trial, father seemed to spend a lot of time trying to convince the court that he should get the adoption assistance, and he spent more time doing this than he did presenting evidence as to mother's earnings capacity so that the court could impute income to mother. At the trial, this is a quote, "Father presented no evidence of her, being mom's, vocational abilities or of any opportunities she might have to earn additional income. The father didn't, for example, show that the mother even could go back to work as a deputy sheriff, or that there were opportunities for her to work in related fields. He didn't, for example, show that she had the opportunity to earn money as a supervisor in a security company, or might have worked in some auxiliary capacity for her old employer. The father was content merely to point to the fact of her retirement and the fact of what she had earned at the time of her retirement." The trial court recognized that father didn't meet his burden of proof showing mother's ability and opportunity to earn and declined to impute income to mother. The court ordered father to pay mother $388 per month in child support, and father appealed. The Court of Appeal affirmed the trial court's order. The Court of Appeal held it is the moving party who bears the burden of showing sufficient facts to establish the change of circumstances that justifies modifying what a previous court has already wrought. They cited in re marriage of Leonard and in re marriage of Stevenson. The court further held simply showing that the mother had retired before the age of 65 and what she made before her retirement was not enough to show ability and opportunity to earn. Father filed the motion to modify child support, so father was the moving party, and so it was his burden to show that mother had the ability and opportunity to earn, basically show what her earning capacity was. Although father was the custodial parent of one child, mother and father both had 50-50 custody of the other child, so this case can still fall into the category of imputing income to a custodial parent. Also, if DCSS, Department of Child Support Services, had been involved, mom would have been called the custodial parent in their system. But anyway, mom was the parent receiving support. The court declined to impute income to her because dad didn't meet his burden of proof. Next, we have in remarriage of Mosley, and this is a case with the following relevant facts. Mother and father were both attorneys. They were married and had 5 children. When they divorced, father was ordered to pay child support based on his high income as a successful real estate attorney with a law firm. Several years after the divorce, there was a downturn in the real estate market. Father lost his high-paying job with the law firm he was working at and took a job with a home builder. This job had a lower base pay with the ability to earn substantial bonuses at the end of the year. And when I say substantial, I mean the bonuses were bigger than his base pay, or they had the ability to be. Anyway, once his year-end bonuses were included, father had about the same amount of income with the home builder as he did with the law firm. The problem was most of father's net income each month went to paying child support and left him with very little to live on. And then at the end of the year, if he got a bonus, he would get a great big bonus and then he would be back in black, so to speak. So this wasn't sustainable for father, and he filed a motion to modify child support. By this time, the children were nearly grown. The trial court found there was no substantial change of circumstance and declined to modify child support. The Court of Appeal reversed the order of the trial court and remanded the matter so the trial court could recalculate child support consistent with the opinion of the Court of Appeal, taking into consideration the way father was paid and to consider imputing income to mother. The Court of Appeal found that father met his burden of showing a material or substantial change of circumstances in order to modify the order. Because in order to modify an order, you have to show this is a child support, spousal support, or a custody or visitation order. You have to show that there's been a substantial change of circumstances. The court further held the trial court in determining father's monthly income shall found its award on father's base salary exclusive of a speculative bonus. However, any bonus actually received must be counted as part of father's annual gross income for purposes of spousal and child support obligations. Consequently, the court must include in its order a method for requiring father to pay support obligations based on any bonus income that he may in fact receive. It may, for example, fashion an additional award over and above guideline support expressed as a fraction or percentage of the discretionary bonus actually received. The court cited in remarriage of Osler-Smith. And situations like this one where the court often uses a bonus table or orders the party to pay a percentage of the bonus as child support to the other party, and these are often referred to as Smith-Osler orders. And that's because of that case in remarriage of Osler and Smith. So with regard to imputing income to mother based on her earning capacity, the court held, as indicated in Cheriton, with regard to the determination of annual gross income for purposes of child support, Section 4058 Subdivision B provides, the court may, in its discretion, consider the earning capacity of a parent in lieu of the parent's income, consistent with the best interests of the children. In this case that we're discussing here, the court suggested the trial court use a Smith-Osler order as part of the child support order to make sure father's bonus income was considered for purposes of support and to make sure that father was not paying most of his net income toward child support each month. And the court held that income may be imputed to mother so that child support was based on mother's earning capacity if it's in the best interest of the children. In remarriage of Cryer. So this doesn't discuss imputing income to a custodial parent in the sense that it imputes income to the parent having the majority of custody. However, it discusses imputing income to the parent receiving child support, so it's still relevant to the discussion. Relevant here, this case includes the following facts. Father is John Cryer, co-star of the TV show 2.5 Men. Mother was also an actress, but had not had a role in years and had no income. Mother and father were married and had one child. Mother and father divorced. After mother and father divorced, mother had primary physical custody of son, meaning she had more parenting time than father did. Father made a lot of money, over $250,000 a month. As part of their divorce, mother and father agreed in a stipulated judgment that father would pay mother $10,000 per month in child support. Mother and father both remarried different people. Mother later divorced her new husband. Several years after mother and father divorced, mother's younger son, not from the marriage with father here, but from her other marriage, was injured at mother's home. The Department of Children and Family Services, commonly called CPS, got involved, and both mother's children were removed from her care. Son went to live full-time with father, and at first, mother had limited visitation with son. It amounted to about 4% parenting time. Her visitation increased when she started being able to have visitation with son in her home. Father filed a motion to modify child support since he basically had sole physical custody of son. The court ordered father to continue paying $10,000 per month child support through the end of the year, and then at the beginning of the next year, child support dropped to $8,000 per month. Obviously, father was not happy with this, especially because guideline support was $1,141 per month. The court found that it was in the best interest of the child because without the child support, mother would lose her home and be homeless. It was in son's best interest to be able to return to the home he lived in with mother. Continuing to get this child support would allow mother to have regular and consistent contact with son. Dependency matters, the dependency matter was still in progress, though it was taking longer than normal. Dependency cases can change quickly, and so mother could quickly get custody of son back. Father was an extraordinarily high earner, and guideline child support would be unjust and inappropriate under the circumstances. I should do a video on extraordinarily high earners. I've never actually dealt with an extraordinarily high earner case because we just don't see them in my counties. But they're kind of interesting, and because they're interesting, I should do a video on them. Anyway, relevant to this discussion, father argued the court abused its discretion in ordering him to pay significantly more than guideline child support when he had nearly sole responsibility for son. Father also argued the court erred in declining to impute income to mother based on her earning capacity. The Court of Appeal agreed that under normal circumstances, this child support order would have been an abuse of discretion, but stated that these were not normal circumstances. For one, the dependency matter was moving really slowly, and for another, father was an extraordinarily high income earner. The Court of Appeal cited a number of sections of the Family Code when stating that child support is normally calculated based on a formula found in Family Code Section 4055. This formula is presumptively correct. Family Code Section 4057A and 4053K, but may be rebutted by admissible evidence showing that application of the formula would be unjust or inappropriate in the particular case, consistent with the principles set forth in Section 4053. The court further cited sections of the Family Code as follows. Section 4053 sets forth a number of principles, foremost among them being the protection of the child's best interest. The guideline seeks to place the interests of the children as the state's top priority. 4053E. Among other principles, Section 4053 also provides, in subdivision A, that a parent's first and principal obligation is to support his or her minor children according to the parent's circumstances and station in life. Subdivision D, each parent shall pay for the support of the children according to his or her ability. Subdivision F, children should share in the standard of living of both parents. Child support may therefore appropriately improve the standard of living of the custodial household to improve the lives of the children. In light of these principles, departure from the standard child support formula may be appropriate when application of the formula would be unjust or inappropriate due to special circumstances in the particular case. And this is Family Code Section 4057B5, so long as the variance is consistent with Family Code Section 4053. By the way, I'm not going to provide a link to all these sections of the Family Code. There's one link to the Family Code in the description, and then from there you can navigate to the other sections of the Family Code. Basically, all of this means that if a parent is wealthy, the parent needs to pay child support accordingly. The parent can anticipate paying a lot of child support, and the parent may be ordered to pay above guideline child support if the guideline would be unjust or inappropriate due to circumstances in the particular case, and the child support paid may improve the standard of living of the custodial parent's household. The court held, we find that the trial court's decision was well-reasoned and consistent with the principles of Family Code Section 4053, especially the principle of protecting the child's best interest. As to imputing income to mother, the Court of Appeal notes in a footnote, we do not find any fault with this decision. Whether earnings should be imputed to an unemployed parent is a matter addressed to the trial court's sound discretion. And they cited in remarriage of Graham. A court may impute income only when it is in the children's best interest. They cited Cheriton. Father does not explain how imputing income to mother would have been in the child's best interest, and we discern no abuse of discretion. Basically, this means that the trial courts have the discretion to impute income to a parent. Father bore the burden of proving that the court that imputing income to mother was in the child's best interest, and he didn't do that. Next, we have in remarriage of Fick. So this is a case in which mother and father were married and had 2 children. Mother had 95% parenting time, so she was the custodial parent. Father worked as a real estate broker, making a decent sum of money, and he had 2 rental properties. He made $8,088 per month. That included all of the sources of his income. At one point in the marriage, Mother had a number of high-power jobs. She lost the last one because a new CEO wanted a man in the job, so she was let go and given a severance package. These jobs required a lot of travel, nights, and weekend work. At the time of the divorce, Mother made $251 per month from a startup business. The startup business allowed Mother to be home with the children in the evenings and on weekends. The court imputed income of $13,333 per month to Mother, and this was allegedly based on a job that Mother turned down, although the math didn't really pan out on that, and the Court of Appeals brought that to attention in their ruling. Anyway, Father was ordered to pay child support to Mother. Mother was ordered to pay spousal support to Father. So once child support was offset by spousal support, Father owed Mother $668 per month. And the trial court did not find that imputing to income was Mother was in the best interest of the children. So that finding was specifically absent from the trial court's decision. Mother filed an appeal. The Court of Appeal reversed the child support and spousal support orders and remanded both issues for further proceedings consistent with the court's opinion. The Court of Appeal found that the trial court abused its discretion by imputing income to Mother without an express finding, supported by substantial evidence, that imputing income to Mother was in the best interests of the children. The trial court abused its discretion in ordering Mother to pay child's spousal support to Father in this case. The Court of Appeal cited Cheriton and Mosley and Cryer and Family Code Section 4058B in finding that imputing income to the custodial parent must be in the best interest of the children. The court stated, "In the case before us now, however, there was no finding imputation would be in the children's best interest, nor was there any finding Father needs any monetary break to increase his visitation time. And in fact, what evidence there is all points to an affirmative detriment to the children resulting from imputation. First, obviously imputation has the objective effect of making less money available for the children. Second, imputation under the circumstances of this case means giving the custodial parent an incentive to leave 2 teenagers alone on evenings and weekends." As to the spousal support order, the court basically found that Father was self-supporting with hard money monthly income, and he walked away from the divorce with more assets than Mother, and Father didn't need the additional help through spousal support. So there we go. That's imputing income to a custodial parent or the parent receiving support. Basically, the court needs to find that there's an ability and an opportunity to earn, and that imputing income would be in the best interest of the children. The parent asking that income be imputed bears the burden of proof that income should be imputed and it's in the best interest of the children, but they need not prove that the parent would actually be offered one of the jobs that they're showing is available. So there we go. It seems that courts less frequently impute income to a custodial parent or the parent receiving support, although it does happen. And the court needs to specifically and clearly make a finding that imputing income is in the best interest of the children, and that finding needs to be supported by substantive evidence. So this was not legal advice. This was for educational purposes only. We sure appreciate you tuning in. Go ahead, like the video, subscribe, ding the bell so that you get notification when we upload future content. If you have any questions or comments, you can put them in the comments below. Any answers will not be legal advice. And if an answer could possibly be legal advice, then we'll probably refer you to the family law facilitator in your county. This video applied to California cases only. And let us know if you'd like us to do a video on any particular topic. Sometimes those questions and comments in the comments below find themselves into a video as well. So again, thank you for tuning in. We'll see you in the next one.